I'm Rob Deutschmann, and I've been serving personal injury victims for over 20 years. The steps in the litigation process are complicated, and it's important to get a personal injury lawyer involved as soon as possible. The purpose of litigation is to obtain compensation for the injuries you have suffered in an accident, to be compensated for something you have lost. General damages include compensation for pain and suffering. Special damages include lost income, both past and future treatment and medical costs, housekeeping and home maintenance expenses, and any out-of-pocket expenses. The first question is, should you sue? The personal injury lawyer will identify the at-fault parties and assess the potential damages. Every lawsuit is different, and it's very difficult to predict the outcome. While most claims will resolve through settlement negotiations or mediation, some will proceed to trial. All investigation and preparation for a claim is done with the expectation of going to trial. The next step is to send a notice letter to the at-fault party indicating that you have a claim and that they are to notify their insurer about the claim. The lawsuit has to be commenced within 2 years from the date of the accident or 2 years from when you discovered that you had a claim for damages. Your lawsuit is started with the filing of a statement of claim. The statement of claim outlines the damages you are seeking and provides an outline of your case, including the basis for the at-fault party's liability. The numbers listed for damages are always very high. They are not the amounts that we usually expect to settle your case, but are high in case your injuries get worse and your damage claim increases. The defendant insurer will select a law firm and respond with a statement of defense. During this period, we will be gathering documents, including medical records, which provide the support for your damage claim. Note that a great deal of personal information will be shared with the defense. An examination for discovery is then scheduled. This provides all parties with an opportunity to question the other side about the claim. The questions to the plaintiff are wide-ranging and will cover a number of areas including your pre- and post-accident health, the impact of your injuries on your ability to work, and on your activities of daily living. There will be requests for updated medical and other information. These are called undertakings. Settlement discussions will often occur after the discovery. This can be done directly between the parties or with the assistance of a mediator at a settlement mediation. No settlement can be completed without your instructions. If your matter is not settled through mediation, then a pretrial will occur. This is a meeting between the parties and a judge. The judge will provide an assessment of liability and quantum of damages. This is another opportunity to try and settle the case. The judge that attends at the pretrial will not be the judge at trial. Finally, after all the steps have been completed and a settlement is not reached, then a trial will occur. The trial can be conducted before a judge alone or with a jury consisting of 6 people. A trial will normally take 2 or more weeks. It will involve expert medical witnesses and treatment providers. You, your family, friends, and co-workers will also provide evidence. The outcome is uncertain. The only certainty is that there will be a final verdict. It is impossible to predict how long your case will last. However, if your case proceeds all the way to trial, then you can expect that it will be 3 or more years before it is finally resolved. Our personal injury team will help guide you through the process. I'm Rob Deutschmann, and I've been serving personal injury victims for over 20 years. Our personal injury team is committed to ensuring you receive full compensation for your injuries. We are committed to your future.